Hello and welcome back to another video on my channel. Today we're going to be looking at Midpage. Now, right off the bat, this is not really a review of Midpage. If I were giving a review of it, spoiler alert, I would say it's a great tool. They have a videos already up on their YouTube about how it works and its utility. And I think if you're looking for something that could help you be more efficient as an attorney in your research, you should check out Midpage. But one thing we had, this past semester in my large language models course for lawyers was one of the representatives from Midpage came and spoke to us, and we kind of agreed that Midpage is not a tool for cutting edge issues. It is a tool for areas of the law that are well established, and that's just not what we're going to be trying to use it for in this problem, and that's probably not what most attorneys would want to use it for either. So, for most attorneys, this is a great tool because you're working in established areas of law. But today we're going to be trying it on a more cutting edge issue, more specifically Brady rights to material and exculpatory evidence, but in a new area, or more, unaddressed area, which is prior to the plea agreement being entered by a defendant. Do they have a right to that information? Currently, the answer seems to be no, but there is something of a circuit split. And yeah, so let's go ahead and try out this problem. I'm going to share my screen. All right, so we're going to kind of be doing a live reaction to mid-page. So I've never, I've watched a single tutorial on how to use it. And I kind of want to give you a feel for what it's going to look like when you first come into it. So I watched the tutorial video and I have my prompt already ready. And what will really impress me is if Midpage is able to give me the circuit split, even just a few of the cases. So if we get the Seventh Circuit's McCann case, the 10th Circuit's O'Hyre case, the Ninth Smith case, the First Smathur, the Friedman case, the Alvarez case is huge. I really want that to come up. And there's also a Mansfield case. We get any one of those, that's great. Brady versus United States is great, and Brady versus Maryland is the bare minimum. So, with that being laid out, we know what we're looking for, and you can't say you know, we'll just see what happens. I want them to do well. Please provide a detailed analysis of whether defendants have a due process or Brady right to access material exculpatory evidence before entering into a plea agreement. Additionally, does the defendant's lack of access to material exculpatory evidence prior to the guilty plea negate the requirement of knowing and voluntary waiver of rights? And let's also ask it, I don't know if it's going to understand this question. What is the circuit split? I don't know what it's going to do with that last part of the question. That might not really be uh, helpful for this LLM. Guys, I like this. Alvarez came up. It's the case from 2018. I'm happy. The rest of this, I don't really know about. Um, so I'm supposed to have, yes, the add column, outcome. Yeah, let's do that. Um, Yeah, I can say this is correct. Familiar with this one. I'm surprised that it's not bringing up, um, maybe the Ohiri case, um, or the Mansfield case. But one of the things I will note about Midpage is the representative talked about having um, a more limited library than Westlaw or Lexis. And so more recent cases, sometimes they don't have the Mansfield cases from 2022. So that could be a potential reason why we're not seeing the Mansfield case, but we are seeing, the Alvarez case. Now, I think another reason why Alvarez is coming up is because I asked circuit split, and they specifically address what I would refer to as a mirage of a circuit split. They kind of debunk why the seventh, ninth, and 10th circuits got it wrong in their decisions. So, all right, trying to think. So if I were just looking at this, I'd say this did a pretty good job. Let's go ahead and see what it tags in the Alvarez case. Because one of the cool features of Midpage is it's going to generate some comments and maybe it'll just draw our attention. So right now, I know I want it to take me to sort of like, I think it's near the last two pages where it debunks that circuit split. I've asked about it, so let's see if it kind of remembers that because it's in the context window. Um, yep, and here we get a nice overview. Uh, it's en banc, reclaim, non-disclosure. There is no constitutional right, reaffirming the existing Fifth Circuit precedent. Okay. Circuit Court previously held no constitutional. Okay. First, second, fourth circuit skeptical about Brady plea approach. Cool. Pre-plea approach. Wow, this is cool. Um, where is it going to take us next? Seventh, ninth, and tenth. No potential constitutional distinction for exculpatory evidence pre-plea. Guys. This is huge. Supreme Court's Ruiz distinguishes between impeachment and exculpatory evidence, suggesting exculpatory evidence may require disclosure pre-plea. That is what they are saying, although there's an argument to go against that. But man, I'm impressed. Um, reaffirms the circuit's precedent. Yeah, guys. All right, mid-page is a good tool. I like that. I really like that. Um, Let's go down and see if any of the other cases I'm aware of are here. No, not looking like it. But maybe if we go back to Ruiz, I wonder if it has that feature where I can click on cases within their case. I'm sure you can, but let's just make sure. So we go back. What does this do if I click circuit split? Wow. Okay. For a second. And then here I could go to the new, yep, to those cases. Let's see how it characterizes them. All right. I'm just going to end the video there. I really thought this was, I'm very impressed. I asked for the circuit split, and although, it didn't bring up as many of the cases I wanted to, it brought up the most important case. You asked for the circuit split, and it brought up the case with that. Now, how would I have known? I'm trying to imagine this. where I guess I would have seen Fifth Circuit and that would have stuck out to me. Let's see what the Ninth Circuit said. And I don't actually know this case, okay? So let's open it up fully. It's generating comments. Yeah, Ruiz did leave that open. Constitution doesn't require pre-plea disclosure of impeachment evidence. Yep, that's what it says. Possible circuit tension. Ninth Circuit precedent may not align with Ruiz. Yeah, no kidding. Because your decision in the Smith-Baldwin case didn't cite the Supreme Court. It cited an authority before Ruiz. Um, that was from itself, from the Ninth Circuit. So yeah, that's going to be a problem. Okay, let's ask it. Okay, so let's say I just don't want to read any of this. I just want to ask it questions. Withheld potential impeachment information regarding credibility. Okay, so this one's about impeachment evidence, not which, there's overlap, and that's a whole complicated conversation in itself, but didn't directly resolve. Of course not. All right. Well, ultimately, I'm very impressed with Midpage, and it passed my test. It didn't get nearly all the cases, but it did get this Fifth Circuit case, which, in my own research, was by far the most important because it's going to it's going to point you in the right direction for all the other circuits. So, great job, Midpage, and I'll just end the video there.